So Williams-Yulee v. Florida Bar presents the question to the court of the constitutionality of a judicial rule of ethics, so a canon in Florida that prohibits judges from requesting directly that potential donors give them money. The rationale for the rule is really twofold. First, empirical evidence shows that judges are affected by campaign contributions. We would expect them to be more affected when they've asked for a contribution and received it or perhaps not received it, on the principle of a sense of reciprocity. You make a donation to me in response to my request, I'm going to be more likely to feel obliged to you in the future. But that's only one thing that Florida was seeking to do through this canon at issue. The second thing is that the public perceives, even if in fact a judge is not affected by asking for a contribution, perceives that the judge would be affected. So by prohibiting direct solicitation, you're essentially seeking to increase the public's confidence in the courts, and confidence in the courts is absolutely vital to their success. I would put this case in the context of campaign finance litigation generally. I think this litigation and the challenge is not principally about protecting the speech rights of judges. I think it's about expanding the ability of donors to give without any restriction. And so I think this case has to be thought of as part of campaign finance regulation litigation. So in this case, both the petitioner and respondent, the state of Florida, encouraged the Supreme Court to grant review because of the uncertainty associated with the split in the circuits. So in general, yes. So whenever the Supreme Court grants cert, we assume that means they're going to favor the petitioner. We call it offensive grants, defensive denials. They deny cert when they want the lower court decision to be the law. So yes, normally we'd be concerned. This case is a little strange because both sides asked the court to review.